quite full and there's all this media going on, but I'm going to remind you and request that this is still a court of law. I'm expecting extreme calmness, order, as the court procession goes on, and silence. Those who have their phones on, kindly have them in silent mode or switched off. I do not expect any distractions under this matter.
Second year for Samuel Ronald Rwanda and Bayan Fulinawe. Bayan Fulinawe and Pura.
Hello, microphone 1, 2. Hello, audio testing. Hello, microphone. Hello, audio.
Of the Human Rights Enforcement Act, Cap 12. And it's about enforcement of rights and freedoms by magistrates' courts. Commander first to address your jurisdiction and then the proceed. On the question of jurisdiction, Your Worship, it is subsection 1 of section 5, which provides that a magistrate's court, subsection 1 of section 5, which provides that a magistrate's court shall hear and determine an application relating to the enforcement and violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution in any of the circumstances not referred to in section 4, subsection 1, because those ones are for the High Court, Your Worship. That is the jurisdiction vested in this Honorable Court. And the procedure, Your Worship, is also provided for, or rather stipulated under subsection 2, that the application under subsection 1 may be made in any language, orally, in any language, orally, or in writing, or in any other form as may be prescribed by regulations. So there is a wide latitude on the procedure, Your Worship, and we are seeking to make it orally before you. And finally, on the procedure, subsection 2 of section 7, subsection 2 of section 7 provides that where a human rights matter arises in any proceedings before a magistrate's court, the court shall immediately stay the proceedings in the main matter and first determine the human rights issues raised. Where a human rights matter arises in any proceedings before a magistrate's court, the court shall immediately stay the proceedings in the main matter and first determine the human rights issue raised. That particular provision, Your Worship, is couched in mandatory terms, and we seek your indulgence, Your Worship, that we first deal with the human rights issue in accordance with the law. And the human rights issues we are raising, Your Worship, are as follows. Number 1, Your Worship, deprivation of liberty of A1 Dr. Besigye without any lawful justification, contrary to the provisions of Article 23 of the Constitution. Article 23, Subarticle 1, provides that no person shall be deprived of personal liberty except in any of the following cases. A, in execution of a sentence or order of court, and so on and so forth. So in this particular case, Your Worship, facts speak for themselves that Dr. Besigye is in the custody of the prisons authorities who are guarding him here. Yet this Honorable Court granted him bail. It's on record. Court granted him bail. To Your Worship, he has no any pending charges whatsoever under any court of law in Uganda. It's not there. For the record, Your Worship, previously, there were charges that had been preferred against him before the defunct General Court Martial in Machindye, which charges were terminated, rather the charges and the proceedings were terminated by the Supreme Court in its landmark decision, Your Worship, of 31st January, which I'm sure court has taken judicial notice of. And the state is aware of this. Your Worship, it's straight law that one cannot be on remand without a valid remand warrant, without a court order. It's straight law. No person can be on remand without a valid court order or remand warrant. We challenge the state and the prisons authorities to produce any valid remand warrant under which they are keeping the applicant, who is their chosen person, Dr. Besigye, in custody in Luzira. There is none. And therefore, court cannot countenance that egregious abuse of the Constitution, particularly Article 23. Your Worship, which is also the other right, which is also granted under the Constitution, Article 23, Sub-Article 3, which provides that a person arrested, restricted, or detained shall be informed immediately in a language that the person understands of the reasons for the arrest, restriction, or detention, and of his or her right to a lawyer, and so on and so forth. This provision is quite instructive, that a person whose liberty is curtailed, who is restricted, who is detained, shall be informed of the reason as to why he is in custody or is in detention. Your Worship, Dr. Besigye up to now is not aware of any justifiable reason under the laws of this country as to why his liberty is being curtailed. That is a 23, Sub-Article 3. The other right which has also been violated is enshrined in Sub-Article 5 or Clause 5 of the same provision, Article 23. That where a person is restricted or detained, the next of kin of that person shall, at the request of that person, be informed as soon as practicable of the restriction or detention. 2, the next of kin, lawyer, and personal doctor of that person shall be allowed reasonable access to that person. The full import of this provision is that a person restrained or detained has a right to access his personal doctor. Your Worship, your applicant here, they are chosen person, Dr. Besigye, is sick. Last time he appeared, last time this court sat on Tuesday, he even wrote a cheat that he is indisposed. He could not make it. My colleagues and I visited him on Wednesday in Ruzira, and indeed confirmed that he is sick. And the prison's authorities can also confirm that he is sick. But to date, he has not been at all permitted to have his personal physician examine him or offer him any medical support needed. This is a gross violation of Article 23, sub-Article 5, and also the next of kin. The next of kin should know the reason why their loved ones are restricted, or rather restrained or detained. Your Worship, the spouse of the applicant, that is the Honorable Winnie Byanyima, who is in the country, has not been furnished any reason as to why her husband is in Ruzira. On a light note, Your Worship, and to substantiate this matter, today is a Valentine's Day. It's a day for loved ones to share pleasantries. It may sound light, but it's a very serious one. Dr. Besigye should also be with his loved ones today. Not only his wife, but all his relatives. He's a family man. It's a day of families to reunite, to show affection to one another.
Monday, his sister was denied access.
And on Monday this week,
Stella.
no, yes, this week, his sister, Stella, who had gone to take supplies to him, food items, was denied access to him. Finally, on the rights which have been violated, under Article 24, Article 24, Your Worship, provides for the right to respect for human dignity and protection from inhuman treatment. Respect for human dignity and protection from inhuman treatment. The kind of cruel and inhuman treatment Dr. Besigye is subjected to is horrendous, is reprehensible, is preposterous. Your Worship, to be in custody of the prison's authorities without a valid remand warrant, without a court order, is such an egregious abuse of one's right, which court cannot sanction or approve. We may be even on record, Your Worship, even writing a small cheat to his loved ones or the lawyers, whatever, is a tug of war. Just a small cheat. Even when we visit him, the environment is not conducive at all for a lawyer-client interaction or interface. Literally, the prison's authorities participate in the conversation, the discussion. There is no confidentiality. You are seated, you are given a room there, they bring the prison's authorities, they are there, listening to you as you are laying the strategies on how to defend your client. That is inhuman. It's cruel. It's a violation of the Constitution. What are the available remedies, Your Worship? In subsection 2 of section
Just a moment, sorry.
7, we reiterate that particular prayer. Subsection 2 of section 7, yes. The first remedy is to stay the proceedings and dispose of the human rights issues. That's what subsection 2 provides, that this court stays the proceedings. That's our prayer, that you stay the proceedings and first dispose of the human rights issues or violations that we have raised here. In subsection 9, and rather in section 9, orders that may be made by court in human rights cases. Subsection 1 of section 9, where the competent court determines that a fundamental right of freedom has been violated, unlawfully denied, or should be enforced, the competent court shall issue orders it considers appropriate, including an order for compensation. We may not ask for compensation, Your Worship. Your Worship, we pray that you be pleased to invoke the powers of this honorable court under subsection 1 of section 9 to issue appropriate orders, because it gives you the discretionary powers here, Your Worship, that the court may grant orders it considers appropriate. And in our opinion, the most appropriate order this honorable court can give is immediate release of Dr. Besigye from unlawful custody. Immediate release. That is the most appropriate now. The other order, Your Worship, in subsection 2, paragraph C, subsection 2 of section 9, orders which shall include measures aimed at cessation of the continuing violation of human rights and freedoms. To order immediate cessation of violations. And here, Your Worship, if you may add on another prayer.
Release one, cessation. Cessation.
Okay. It's under that provision that, Your Worship, that this court is clothed with the powers to order for the release, immediate cessation. You are clothed with jurisdiction to order for the immediate release of Dr. Chiza Besigye. The other prayer, Your Worship, we are making for regards to violations under Article 22, the last one now, Your Worship, under Article 22, protection of right to life. No person shall be deprived of life intentionally, except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of criminal proceedings under the laws of Uganda. They are threats to the life of the accused person, Your Worship. Threats to life. The circumstances under which he is being detained pose a serious threat to his life. The horrible treatment is subjected to, but even a statement issued by the army, the CDF himself is on record issuing threats that Dr. Besigye shall only leave Luzira in a coffin. He's on record. saying that. That is General Muhoozi Kainerugaba. That Besigye shall only leave Luzira in a coffin. That's a very serious one, Your Worship. So this court is enjoined to protect the life of the accused and all his other rights. Of course, the other threats that will be subjected to firing squad in June and whatnot, but we wanted to single out the one relating to his imprisonment now, that will only leave Luzira in a coffin. So we pray that, Your Worship,
criminal sanctions against the DPP and the prisons.
and the other prayer, the last one we are making, the prayer, Your Worship, is in subsection 2 of section 9. That is paragraph 5 and 6. That the court can issue criminal and other judicial or administrative sanctions against the persons liable for the violations criminal and other judicial or administrative sanctions against the persons liable for the violations. To start with, these ones. These ones, Your Worship.
And the battalion behind you.
All these security officers in charge of his custody, starting with the Commissioner of Prisons, should be sanctioned. Mr. Byabashaija Johnson should be sanctioned. Your Worship, the Director of Public Prosecution is equally liable in this, together with the Attorney General. They are equally liable in this. They should be subjected to criminal sanctions for violating Dr. Kizza Besigye's rights. We do so pray.
Non-repetition.
We do so pray, Your Worship. Your Worship, if I may be permitted with the leave, Your Worship, I'd left out one prayer in 6 because I had highlighted it, Your Worship, to guarantee non-repetition, that court, amongst the orders that can be issued, guarantees of non-repetitions. So court is again enjoined to make some safety measures and provide mechanisms to ensure that there is no repetition of violations. In other words, they should not be allowed today to go back with Dr. Kizza Besigye to Luzira. They shouldn't be allowed by this honorable court to take him back to Luzira, because that will be, again, violation of these provisions. We do so pray, Your Worship.
And there is no ruling that is illegally in prison. You know, you cannot be in prison and celebrate Valentine, as Mylan colleague wants. It won't happen. There are inconveniences of life. Or have total. So, you know, I'll sum up that this court has no jurisdiction to make orders arising out of its incarceration. That is in as far as these orders arise from this criminal matter. They should have made a separate application to this honorable court. For his incarceration has no bearing on the case before this court. 2, if I am wrong and indeed this court has the jurisdiction, he is not illegally in custody. He is in a lawful custody and the Supreme Court judgment is clear, he is in lawful custody. So, Your Honor, I would pray that the prayers by my land colleague that Attorney General DPP be reprimanded and the prison. No, Your Honor, what they are doing is lawful. So there is no illegality that has been made. So, Your Honor, I would pray that this honorable court dismisses the application. And Your Honor allows us, Your Honor, we had made the first and allows us, this honorable court should allow us to present our last witness today, Your Honor. And we have all these times been chastised by my land colleagues for not presenting witnesses. When we present a witness now, my land colleague doesn't even want to hear about the witness at all. So we pray.
The submissions of both the defense and prosecution have been heard. The court takes cognizance of the fact that human rights violations, once brought to the attention of the court, must be dealt with expeditiously. However, several provisions of the law, authorities, and scenarios have been placed before the court by both the defense and prosecution. In reply as well as rejoinder, the court owes it to itself a duty to carefully internalize and draw the provisions of the law and violations cited into perspective before a decision on the prayers can be made by both defense and prosecution to be arrived to. The matter is going to be given an adjournment for a ruling on a date. Council, I have the 28th of February, if it's available to you.
Why not Monday, Your Worship? Today is 14.
Can you work with the 20th of February? Next week is the 20th. It's within next week, 20th of February. Thursday, the 20th of February, if it's available to you.
Anything next week is available to us.
This one is next week, I think. 20th February is next week, Thursday. Just to allow me time to also internalize all the submissions you've bombarded me with. The prosecution has made submissions. I also avail myself a chance to look at the authorities and the provisions of the law. Then we can reconvene for a decision. And so there might be no point in me giving you a date when the court will not be able to entertain a sitting. But Thursday is very open and Friday the 21st. All within next week. Is it available to you?
Any big event was for this matter, Your Worship. The soonest we have it disposed of, because we are talking about rights, Your Worship.
So the matter will be adjourned to Thursday, the 20th of February, for a ruling. Accused is on bail in this particular matter, and his bail shall extend until then. However, the court is not blind to what is happening and that is being produced by prison authorities. So by this adjournment, I'm also ordering prison. If on such a date is still in your custody, produce him in court.
We hope they will not treat this as a remand order, Your Worship.
I do not think they need a remand warrant. They are here with the gentleman. Will you need that? And they've had the date, the 20th of February.
Because he's on bail. But they may misconstrue.
Prisons never disobeys orders of court, especially when they are present. It has never happened, at least not in all my years of service. So I don't imagine that they will not produce him unless doctor himself opts not to appear.
No, our worry was for them to misconstrue this as an order of remand.
No. I have clearly stated in this particular matter, Dr. Kizza Besigye is on bail. His bail is extended till that date. However, I am not blind that he's incarcerated somewhere in a different matter. So I'm ordering the people who are here that in the event nothing has changed and is still with them, they produce him on that date. It is as simple as that at 10 a.m. With that said, Council, I have other matters ongoing. Members of the Fourth Estate, if you could vacate my court so we can proceed with other hearings.
Well, first of all, the situation is really devastating to us. You can see what is happening to Dr. Besigye. You know him. He's a very strong man. But you could tell from his appearance today, although he's not well. Any keen observer, you know how Dr. Besigye strong he is. You know him very well. To be in that kind of state, it's a matter which is really worrying to us. And it's what compelled us to invoke the provisions under the Human Rights Enforcement Act, which was enacted to address situations like this. The framers of the Constitution provided that latitude to people who are faced with egregious abuse of rights to have quick remedies. It's the reason they made that provision very flexible. Section 5 of the Human Rights Enforcement Act of 2019, which was enacted in operationalizations of Chapter 4. Are we together? Because that particular act was meant to operate. That particular that act was made purposely to operationalize enforcement of rights under Chapter 4, the Bill of Rights. And the Parliament recognized there are situations where one may informally seek for remedies in exceptional circumstances like this. And the remedies should be made quickly and immediately. It's the reason we had to invoke that particular provision, Section 5, with the hope that it would come to our rescue, to the rescue of Dr. Kizza Besigye. That you can make an application in a language you understand, you can make it verbally, orally there, or in any other manner that court may deem appropriate under the circumstances. So it's a very flexible provision. So that's what we relied upon and cited the litany of violations under Article 23, 24, and other provisions within Chapter 4 of the Constitution. Unfortunately, we have not been favored with a decision today. We leave the court premises with heavy hearts. Personally, my heart is heavy. It's heavy. It's a heart-rending situation to see Dr. Besigye in that state and to witness this impunity of the highest order, because you could tell from the submission of the state, whatever they were saying, they never cited even a single provision of the law. For us, we cited all the laws, but their submission was just casual like that, with reckless abandon. They were so callous, in their response to this, so callous, not minding about the right to life under Article 24 of the Constitution, the right to life. So it's very, very, very devastating in the first place. Very, very devastating. This is what I'm telling you. It's devastating. And I want to emphasize, it's devastating.
What can you say? They are saying that this person is already on bail in this matter, that Prosecution on another court. Concerning these rights that
you see, the person who is admitted to bail must enjoy the rights guaranteed under the Constitution. It's the spirit of Article 23, the right to liberty, the right to freely exercise your freedoms, rather to enjoy your freedoms. No, the spirit of Article 23 is very clear. Why one should be admitted to bail is to enjoy their liberties. So now Dr. Besigye's liberty is curtailed unjustifiably and illegally. So it's the reason we brought to the attention of this honorable court that their orders they gave admitting Dr. Besigye to bail have been rendered illusory, have been rendered nugatory, useless, because right now he cannot enjoy the freedoms granted to him by the courts of law. This very court which said, please, you are free to go back home and attend to the proceedings or the trial from the comfort of your home. 2, the right to have access to your personal physician. It's also guaranteed under the Constitution. Right now, Dr. Besigye is in the hands of prisons authorities who have no capacity to take care of his life. Those doctors in Luzira cannot manage his life. And it's a right guaranteed under the Constitution. For heaven's sake, one wouldn't want to try a dead person because practically it's impossible. So it's the reason we believe, and this renders credence to the statement made by General Muhoozi Kainerugaba that Besigye will only leave Luzira in a coffin. All the melodrama now characterizing, whatever is happening, all these shenanigans being perpetrated by the state are calculated to keep Besigye under incarceration so that he leaves that place in a coffin, as stated by General Muhoozi. That's all. That's their mission, nothing else. They just want to have him dead under all circumstances. They just want to have him dead, nothing else.
Counsel, following that, you want to test that the habeas corpus which was filed in the High Court is not taking place?
You see, we are exploring all available options under the law. You see, the beauty with the law, it creates different doors. Habeas corpus ad sub judiciendum is one avenue one can explore when your liberties are curtailed, and that is a matter before the High Court. But there is also another room, I don't want to call it a window, another door here in the Magistrates Court under the Enforcement of Rights Act, Section 5 and Section 7, that one can also pursue. There are also other options. This is about enforcement of rights. The other one is habeas corpus. You can also ask for judicial. You can bring a multitude of applications in different courts. We have even the option of going back to the Supreme Court. We can go anywhere for enforcement of this judgment. So this is what we have chosen. Even in Parliament, by the way, is also enjoined to protect people's rights and liberties, to also protect, actually to guard against violation of the law. They are duty bound, if indeed they were to live up to their mandate, to uphold the rule of law. It's an obligation, imposed on Parliament. So all these are available options. It's not that we are gambling here and there or trying here and there. We know what we are doing. So this is an avenue duly provided for under the law, that you can seek to enforce rights before a magistrate's court informally. And this is what we have done. Unfortunately, again, the magistrate has told us to wait for another 1 week. A week is too long for somebody whose life is in danger.
How true is it that
You, the media people, you have also witnessed this. Even when you go there, they can't even allow any of you near the main entrance of Luzira. Even here, you cannot. We can try here and see if one can access him. It's not possible. We have told the court, even ourselves, when we go there as lawyers, we can't have that confidence required if you are to interact with your client. That exclusive environment where you can have a discussion in camera, in confidence, is not there. So this is the horrible situation we are talking about. I cannot act in any way. Tulaba ffenna wano tuli banyiikaavu. Dokita Yabaga tuli banyiikaavu ekigenze ewala. Tuli banyiikaavu nnyo. Sooka embeera ya Dr. Besigye mumanyi. Dr. Besigye musajja omuvumu mu mbeera yonna. Naye olaba atuuka okuba nga abeera nga bw'abadde mu kooti nga bwe mumulabye. Singa abadde mulala muntu atya obulwadde yali badde ng'alina ku stretcher. Singa abadde muntu omulala atya obulwadde. Naye wakati mu kwegumya asobola okubeerawo era omulabanga embeera ye. Mu mbeera eno twalisuubidde nti omulamuzi yalikoze ekiri mu mateeka. Annyonnyodde n'agamba yeetaaga okutumya amateeka, authorities n'ebirala. So a week enamba gy'atuwadde okola ruling etuleeseemu evvuunya mu mutima. Kubanga abakola ssemateeka ne bateeka mu chapter 4 oba Bill of Rights baali bakitegeeza nti waliwo eddembe ly'obuntu erituuka n'okusaanyaawo obulamu bwo. No, waliwo embeera ey'okulinnyirira eddembe ly'obuntu ng'etuuse ne ku point ey'okusaanyaawo obulamu bwo. Ekyo kye kyaleetesa Parliament okuteekawo Enforcement of Human Rights Act eya 2019 nega singa embeera ebeesusse ey'obulamuzi ng'ekizimba kisambye eddagala osobola okwekubira enduulu mu Magistrates Court. By the way, bw'otaputa section eyo 5 osobola n'okusanga magistrate wano wabweru ng'ali mu parking n'omugamba owaayo nfa bantwala nagamba nti ate kiki etteeka limugamba nti muwulirize omuntu oyo. Osobola okugamba nti katufuna akameeza wali onyinyonyola ensonga zo egamba mu lulimi lw'otegeera orale mu bigambo bugambo oba mu nkola endala yonna. Osobola omusanga nkugambye ne mu parking wano osobola omusanga mu chambers ze n'omugamba omulamuzi nti munnange bantwala nfa obulamu buggwawo. Omulamuzi alina obuvunaanyizibwa okuwuliriza n'akuwa remedy. Kitwenyamiza nti tuddayo tuvudde mu tugenda kutambula okuva wano nga tetulina ketulina mu ngalo. Tetufunyeeyo remedy n'emu ku ky'obulamu bwe okuba nti talina dokita we bisigadde nga we biri. Ekyokuba nga akyali mu mikono gy'abasibira mu bbwa nga tewali remand warrant, tewali court order yonna emuzisibirayo, kisigadde nga bwe kiri. Ekyokuba nti abarelatives be nabo tebasobola kumulaba, kisigadde nga bwe kiri. Ekyokuba nti ffe nga balooya be naffe bwe tugenda wali okwogera naye mubeera n'abaprisons nga bawulira bye mu planninga, bisigadde nga we biri. So tewali kikyuseewo. Kitwenyamiza nnyo okugamba nti tulinda wiiki namba. Katusabe Omukama atuyambe nti mu wiiki eyo wabenga dokita obulamu bwe tebwongedde kuba bubi. Kubanga bwe bityo we bibeera mu bantu baffe abazze bafiira mu makomera nti embeera ejja etabuka ne badda mu jangu onkwekule ne badda mu kamese etambula ono obulamu ne bwongera okusereba nga bwe gwali ku mugenzi Sseggirinya, then bagenda omuta nga embeera egaye nga takyayinza kudda ngulu. So katusabe dokita aleme kugenda mu mbeera nzibu mu bulamu bwe. Kitunyize okuba tetufunye ruling olwaleero. Kitunyize njagala obategeeza, simanyi nabwe nnyinza kunnyonnyola butya bwe kitunyize okuba nti tuvuddeyo empty handed. Tetulina kye tuvuddeyo n'akamu bwe kati ketuzaayo nti dokita at least afunyewo akalembereza bwe kati. So impunity eno egenda mu maaso erina okukwata ku buli omu, kubanga kikulaze nti chapter 4 manyi kibagamba ekigambo Yerusale ekintu ekiri ekiwowongole nti chapter semateeka bamusokolamu ekinyusi kati kifuuse kiwowongole nti semateeka alina okututaasa mu bill mu chapter 4 Bill of Rights teyinza kutaasa Dr. Besigye olwaleero. Human Rights Enforcement Act eyateekebwawo Parliament okulaba nti omuntu yenna anyigiriziddwa nga atuuse ku kisenge nga obakoze Dr. Besigye teyinza kutuyamba. So kino kyongedde okukakasa nti ekigendererwa kya Mwami Yoweri Museveni ne banne kwe kulaba Dr. Besigye nga kamuntaana, kubanga General Muhoozi yagamba nti Dr. Besigye tagenda kuva mu kkomera okujjako ng'ali mu coffin. Ekyo yakyogera kubanga Dr. Besigye ali ku bail. Kati kooti eno eyamuwa bail yamugamba nti genda obeere n'eddembe lyo ojje ng'owoza kuva bweru. Kakati kitegeeza nti ne bail ya wano nayo tekyagasa. Right to bail tekyagasa kubanga eno kooti yamuwa bail, yamugamba genda weeyimirirwe. Naye kati kooti naye etuuse eyamuwa bail ng'agenda kakati era omulamuzi omulidde agambye nti tumanyi ayina gye bamutadde eyo naye ndowooza bweru w'amateeka naye naffe tetulina kyakkola. In fact omulamuzi alinga kyagambye mu mbeera eno naffe mutusaasire. Kati omulamuzi ne bamuggyako Dr. Besigye gwe yawa bail ne bamumugya mu ngalo ne bamuzzaayo mu busibe obuli ebweru w'amateeka. Kikulaga eggwanga we lityuse mu kye bayita impunity mu bw'amawale mu bw'okumenya amateeka. Kikulaga we tutuuse nti otuuka mu maaso g'omulamuzi eyagaba bail nga naye ekyokukolera takirina. So bwe buwambe bwe tulimu yembeera eyo ey'obusibira mu bbwa ey'abatamanya ngamba okubanga bakola buli kye baagala okulaba nga obulamu bwa dokita busaanawo. Kyekigendererwa katusabe nti Mukama atukwatireko akuuma obulamu bwa Dr. Besigye kubanga ewiiki ennamba nnene ku muntu omulwadde, ewiiki nnamba nnene ku muntu atafuna bujjanjabi, ewiiki nnamba nnene ku muntu atafiidinga bulungi atalya bulungi, ewiiki nnamba nnene nnyo mu mbeera Dr. Besigye gyalimu. Katusabe Omukama atuyamba atukwatireko.